hard to extrapolate from claim. I also think it's important to look at the other cases from last term. Holland versus Brackeen. This was the Indian Child Welfare Act case. The Supreme Court denied state standing to Texas and Louisiana on equal protection claims. And in United States versus Texas, one of them, this was the case about immigration enforcement, the arrest of undocumented immigrants. Not only did the court decline to address the state's claim of special solicitude, it denied standing entirely, treated the states like private parties. Justice Gorsuch, in a concurrence, joined by Justice Barrett and Justice Thomas, said he had serious doubts about the whole special solicitude concept and advised lower courts to sort of leave it on the table going forward. And Justice Alito, in a solo dissent, said, wait, has the court just interred Massachusetts versus CPA? My sense is no, not yet. But we at least have some tea leaves that suggest that the current Supreme Court may not be on board for full-blown special solicitude towards states, which I view as a positive development. I think Julia and Ann would also view as a positive development. In fact, they want to cut down on state standing even more than I do. But if you view it as a negative development, I would pay a lot of attention to the tea leaves in U.S. v. Texas.
I am curious, so like in the future of state standing, Dan or Brian, did you want to jump in on this, or you're like, we just want to, yeah.
No. I think it's a good question. And the thing I wonder about with state standing is really the changing political valence of standing, which you kind of hit on with your comments. I mean, obviously, with the court now more of a conservative majority and the courts in general perhaps tilting in that direction, you might think, oh, it'd be a great thing to have lots of state powers to challenge potential Democratic administrations, set up things for review. So I guess my only observation about this, and I'm not a standing scholar at all, but it certainly wouldn't be the first time that the political valence of standing would change quite dramatically. I mean, there's a lot of evidence that standing doctrine in general was invented by more liberal justices in the middle of the 20th century who were trying to insulate the burgeoning administrative state from challenge by lots of different actors. So that obviously changed over time. More liberal justices came to abandon standing, but this is pretty well documented in the literature. So I guess it doesn't strike me as implausible that state standing might, dramatically flip in this way, given changing composition on the court, and then also, changing dynamics in the realm of litigators as well. But I think there's also reasons to be skeptical that it will happen here. I mean, we live in an era of high partisan competition, and for the presidency, I should say, and so about half the time. Even the conservative justices on the court are going to have their oxen gored, right? Because you're going to have California challenging, a Republican administration. So I just think it's pretty unlikely that we're going to see any dramatic shifts when it comes to state standing and the kind of political valence of that question. Although on other dimensions of standing, certainly the injury in fact inquiry, the developments in Spokio and TransUnion, I think that we're going to see, still very dramatic changes in that realm, consistent with kind of a conventional story about how standing has a political valence. Any thoughts for you, Brian? Okay. All right.
I wanted to kind of circle back, and I think Dan's last point, like, can we read anything from these sets of cases about standing more generally? Like, do you think the court, with the political composition changing, is going to like read injury or cause it? Are they going to read the other things more flexibly, or do you think it's going to kind of stay with the good old environmental law cases that the Luhans of the world that kind of made it really hard for individuals that aren't directly affected to be able to challenge? I don't know. I'm looking at you, Tara.
So I think in the lower courts, we're seeing some real push against standing doctrine, particularly the Fifth Circuit, where I live. And I don't know yet that we're going to see that same push at the Supreme Court. I thought it was really telling that in a case where I believe Justice Gorsuch, Justice Thomas, and Justice Barrett were probably somewhat sympathetic to Texas's concerns about the Biden administration's immigration policies, maybe yes, maybe no. They used that case to say, we're not super keen on this whole special solicitude for states thing. And they're doing it in the middle of the Biden administration, knowing that there are going to be a lot more cases coming up, presumably knowing even that the mifepristone case was coming up. So I think we're seeing conservative litigants pushing for state standing. I think we're seeing some members of the courts of appeals, not all, pushing for broader standing more generally, not just state, but private party. I don't know that we're going to see that at the U.S. Supreme Court. I do, however, think that when you have a legal movement that pushes in one direction, that can have long-term impact on the future of a doctrine. And I say this as someone who believes firmly that standing doctrine should be apolitical and nonpartisan, and I believe that it typically was in Justice Scalia's hands. And I am greatly perturbed when I see lower courts or any court seemingly motivated by their desire to reach the merits. I don't think most lower court judges are motivated that way. Obviously, litigants are. Litigants are always going to push for whatever is best for their clients. But I hope the judiciary pushes against it. And I hope they read and reread what Justice Scalia, Chief Justice Roberts, and many other scholars have written for decades and decades about the importance of limitations on standing for the separation of powers.
I had one last. Julie, do you want to jump in?
I was just going to say that maybe getting back to Brackeen, that may show us the way where there was standing right for the anti-commandeering claim, but not for equal protection. And I think in terms of going forward with state standing, that might be a good thing to build on. That it really puts, it seems to me anyway, it really means the states can actually get some relief when their ability to govern, as I think you put it once, is actually under some duress.
Right. So I would agree with that. I think you're opposed to that, right?
Not exactly. I mean, it's more. It's not so much opposition, but thought that the cases will come up eventually. But this brings this question that comes up a great deal about: is it so bad if there's a delay in terms? And this makes me think a lot about various controversies concerning facial and as applied challenges. I mean, there are big benefits, it seems to me anyway, but there are some costs too, to having the courts have to get involved only reluctantly. De Tocqueville wrote a great deal about this. At one point, I think he says, but the American judge is brought into the political arena independently of his own will. That was identified in the early 19th century as a very important component of the sort of prestige and importance of the judicial role. And I think de Tocqueville had it absolutely right, where the Supreme Court ends up setting itself up as a possible referee, arbiter of pretty much any major initiative that the president undertakes. I think that does raise complex questions about its legitimacy with respect to the big student loan debt forgiveness plan at issue in Biden v. Nebraska and Department of Education v. Brown. In a sense, the court was put in a lose-lose situation. I mean, if it didn't strike the executive initiative down, it's something that seemed to be very much a highly aggressive use of executive powers beyond the powers that the HEROES Act gave the executive, well, then the court would be standing by, and it couldn't really say, well, we can't do anything about it because no one has standing, because the court had found states to have standing in so many other circumstances. So I think that there's a lot to be said for the court appearing not to be eager or at least quick to accede to being hauled in. And then also I think with the passage of time, Alexander Bickel made this point about standing and case requirements, that it, quote, creates a time lag between legislation or executive action, one might say, and adjudication, as well as shifting the line of the vision. Hence, it cushions the clash between the court and the other branches. And To me, those are words of wisdom. Now, of course, in response, someone might say, oh, but meanwhile, we might have an out-of-control executive branch or legislative branch, and the courts aren't actually doing anything about it. And I guess my response is, well, that's our system, that the courts are not going to do anything about it necessarily immediately. There has to be a case or controversy, and perhaps one that has to ripen in a way that there's a record and so forth. But as I say, not everyone sees it that way.
This does connect with something that I wanted to raise, actually following on something that Tara mentioned earlier with the U.S. versus Texas case. I mean, I think one thing to watch that could change dramatically in standing doctrine is a kind of re-articulation, maybe implicit so far, but maybe explicit at some point, of standing as Article 2 rather than Article 3. As protecting executive power first and foremost. I think U.S. versus Texas, it's an interesting case in the sense that it could have just as easily been framed as prosecutorial discretion, Heckler versus Cheney, non-reviewability, all of that stuff. But instead, the court invoked a pre-Article 3 standing case, one that doesn't even mention Article 3 standing, Linda R.S. versus Richard D. So I think, implicitly in that case, the court seemed to recognize that there's just as good of a case to be made that standing is grounded in Article 2 rather than Article 3. And I know there's a lot of people who have written about this, including Tara. Including Jonathan Adler has a new paper on this as well. So, but I think that's getting some traction, if only implicitly, in the court. And I think that's something to watch going forward. It does raise these concerns about standing doctrine effectively becoming a free pass for an out-of-control executive. So I think that's something we'll have to grapple with going forward. We have to define what executive power really is.
We could go for hours just on this. I do want to go one more minute, though, because when you bring this up, Dan, in the other case, one of the plaintiffs from the Pacific Legal Foundation did have standing originally. He wanted the tax. He was worried about his taxes in his state, and he didn't want the loans. And the Department of Education, this is not going to be an administrative process panel, but they didn't actually ever issue at the outset, they just kind of announced and had a Q&A on their website saying, this is what we're going to do, and we're going to announce this portal, and once the litigation started, they turned around and said, oh, well, now we're going to change the program, and now you can just opt out. You can just push the button, I don't want this money, and standing is gone. And I think the answer is right, that if it started that way, there is no standing. But I kind of wonder, as a matter of kind of executive, do we like the idea that the executive, after it's announced a policy, can eliminate standing by just carving out the people that... I mean, if I go a step further, it also, at least the news reports would say that they were originally going to have it sweep beyond federal student loans and do private loans as well. And the reason they didn't help those additional thousands and thousands of borrowers was because they were worried about standing, and not because it was not the right thing to do as a matter of policy. And I just kind of wonder, does that shift in the middle of litigation? Should that affect how we think about standing? I'm guessing the answer is going to be no. But I don't know, Tara, you seem to look like you're thinking through this.
Yeah, so I think it's unseemly, right? Like we don't like it. I'm sure governments have done this for years and years. Look at the New York State Rifle Association case. I think we have an answer in our laws to deal with that. If someone has actually filed suit and the government up and changes its plan, that's dealt with under the mootness doctrines and exceptions to mootness, and was this voluntary cessation, et cetera, et cetera. If no one's actually filed suit yet and the government changes its program so that the person's not injured, you can say, oh, well, this is sort of questionable government action, or you can say, oh, well, the person's not injured, so nothing to sue about. And I think second guessing this kind of government action would be a really problematic space for the courts in figuring out why the government did or did not do something, because as we both know from our time at DOJ, the government does things for lots of different reasons.
Yeah. Awesome. All right, so now let's move. I don't want to call it the main event. That was the appetizer. The main event is the major questions doctrine, and I'm going to kick it over to Dan. And Dan, I'd love for you to kind of situate Biden versus Nebraska in the larger kind of major questions doctrine development, and just kind of give us a primer on that.
Yeah, happy to do that. I think the best way to understand Biden versus Nebraska is the court saying, yeah, we really meant what we said in the major question quartet cases. So Mila Sahoni, not sure if she's here, but she coined that term for a series of cases in the October 2021 term. The CDC eviction moratorium case, Alabama Association of Realtors, the OSHA vaccine mandate case, NFIB, the CMS vaccine mandate case, Biden versus Missouri. That was the one case that actually ended up upholding the government action. And then finally, and most importantly, the Clean Power Plan case, West Virginia versus EPA. And the key change that these cases arguably made was, first of all, to recognize that the major questions doctrine is a doctrine. They had never named it the major questions doctrine before, but they explicitly did in the West Virginia versus EPA case. So that's one contribution of the quartet cases. They also lay out a pretty specific test for the major questions doctrine, which helped clarify exactly what is required of courts when they are implementing this test. So it's important enough that I think I'll just read you the relevant passage from the case. The court said, in certain extraordinary cases, both separation of powers principles and a practical understanding of legislative intent make us reluctant to read into an ambiguous statutory text the delegation claimed to be lurking there. To convince us otherwise, something more than a merely plausible textual basis for the agency action is necessary. The agency instead must point to clear congressional authorization for the power it claims. So a lot of people looked at that language, myself included, and said this looks a lot like a clear statement rule, a substantive canon of statutory construction that says that a court will only interpret a statute in such and such a way if Congress is super clear about its intent. And courts do this all the time. They create substantive canons and recognize them in all kinds of areas to vindicate important policies or constitutional principles. Critically, the West Virginia majority claimed that it was just building on an identifiable sequence of cases in which the court had implicitly recognized such a doctrine. So there were indeed lots of prior cases, call them proto-MQD cases if you want to. Lots of accounts trace it to the benzene case in the 1980s. More accounts, I think, trace the major questions doctrine to FDA versus Brown and Williamson Tobacco and MCI v. AT&T. I think Louis Kaposi, I'm not sure if he's here, but he's argued that it goes all the way back to 1897 with the Queen and Crescent case, as it's called, ICC versus Cincinnati, New Orleans, and Texas Pacific Railway. So there was some debate about whether there actually was a lineage here. But none of these cases, I think, really on close inspection provide a straightforward precedent for the very specific articulation of the doctrine that we got in West Virginia. And I think in the interest of time, we won't get into too many of the specifics here, but most relevant, when the court did invoke the major questions doctrine, though not by name, in MCI and FDA, it rather explicitly treated the major questions doctrine or the extraordinary questions doctrine as an exception to Chevron. Right, so Chevron deference, we all know, is that doctrine that says that courts defer to reasonable agency interpretations of statutes. The court in those cases engaged in what we might characterize as de novo statutory interpretation. They actually tell us what they think the best interpretation of the statute is. And really the major questions doctrine, to the extent that it played a role, is kind of as a tiebreaker to say, in case you think there's some residual ambiguity here, the fact that this is major would tip us towards this other interpretation that we're going to articulate. Not so with the court's application of the West Virginia articulation of the doctrine. The court engaged in about 2 paragraphs of very, in my opinion, hand-wavy statutory analysis in order to answer only whether there was a clear congressional authorization in the statute, not whether there was a best interpretation that the court was going to tell us what it is. In fact, the court kicked that can down the road and said, we're not going to tell you what the statute means. Now, more generally, the lack of a precedent for the very specific version of the major questions doctrine enunciated by West Virginia left many questions about precisely what the court was doing and how it was justifying this doctrine. And the court was not very analytically precise in its opinion, to say the least. There's at least three possibilities that I can see about what this major questions doctrine is. First, it could be a new clear statement rule, as I indicated earlier, a substantive canon that vindicates some normative theory that the court has, although the theory is unclear. It could just be that this major questions doctrine is just a somewhat confusing addition to the exception to Chevron formulation from prior cases. I think another possibility is the one that Anita Krishnakumar has recently identified in a paper that's forthcoming in the George Washington Law Review. This is just straight up purposivism. It's really not consistent with text rules. I think Brian will speak to that a little bit more. But that's a possibility as well. We really don't know, and the court hasn't told us exactly what this doctrine is. Okay. All right. Now, I just want to say one quick thing about the clear statement rule formulation of things, a substantive canon formulation of the major questions doctrine. If, in fact, the major questions doctrine is a substantive canon, a clear statement rule of some sorts, I think it really is incumbent on the court to provide a normative justification or a legal justification for that substantive canon. I think this is where the court's gotten a lot of pushback. If this is, in fact, framed that way, then there are some people who are concerned about that, including Justice Barrett and many other critics of the court's opinions. Now, to bring this all back to Biden versus Nebraska, I've spent a lot of time talking about the quartet, and hopefully I'm doing okay on time. Yep. Okay. Now, Biden versus Nebraska pretty clearly followed the same script as the major questions quartet cases, but also raised some new uncertainties that I think are worth flagging for discussion. First, the case muddied the waters on what counts as a major question in the first place. The case makes a much bigger deal of the dollar figure involved, the $430 billion that was mentioned earlier, than I think some of the major questions quartet cases did. They were much more focused on the transformative nature of the authority claimed by the agency. But the court spent more time talking about just simply the kind of quantitative value of this student loan forgiveness program in Biden versus Nebraska, which, we need more guidance on what exactly triggers a major questions doctrine. And I think that that's not particularly helpful in terms of sorting out whether it is a qualitative or a quantitative kind of evaluation. Second uncertainty that I think Biden versus Nebraska raised is it complicated this clear statement rule versus exception to Chevron question. So unlike in West Virginia, in Biden versus Nebraska, the court started with a lengthy statutory analysis of the plain meaning of the words waive or modify before offering the major questions doctrine as an additional reason why any residual ambiguity could not be interpreted in favor of the agency. So that looks a lot more like FDA v. Brown and Williamson tobacco than it does West Virginia. So again, I think that just muddies the waters. The third complication here is the case really didn't add much of the explanation of the foundations of the doctrine that observers might have expected. The majority was conspicuously silent on the foundations of the major questions doctrine. Justice Gorsuch, who had concurred in West Virginia and offered his own theory, joined the majority. And perhaps because they had to join together, the opinion doesn't really say anything about the reasons for the major questions doctrine. So that again is an uncertainty that is still lingering after that case. All right, so bottom line, I guess I don't want to take up too much time, but I think Biden versus Nebraska is just the latest entry in the saga of the rise of the major questions doctrine in the last couple of terms. And I think perhaps the most notable thing about it is how little it answers some of the theoretical and foundational questions that arose after the major question quartet cases. It's clear the court wants to move on and treat this as precedent and get the lower courts applying this on a kind of rote basis, but I'm not sure that's how law really works. But we need doctrine to have justifications, and there are very serious questions about the doctrine that I think Brian will also discuss in his remarks.
So you think, Dan, you think Chief Justice Roberts is reading all of the law review articles from all the administrative law officers and oh man, in West Virginia EPA, I really skipped that whole step. So I'm going to go back and now write like 10 pages of statutory interpretation. You're not.
I wonder. I mean, it was pretty odd to read West Virginia versus EPA and see just when it got to that very specific question, what does system mean? It was very short. It didn't really deal with the merits of the question, the way that the dissent engaged with the merits of the question. So I think, to the extent that people called the court out on that, and I think there were people calling the court out on that, perhaps they paid attention to it and perhaps they righted that wrong.
There's also just a rule of 5. You have to get the 5. Sometimes opinions kind of come out that way. The one thing, and I think Dan hit on this, is that if it is a clear statement rule or substantive canon, there's a world of folks, including I think a fair number of us in this room, who would say we're textualists and kind of old-fashioned textualists. And some of us have been uneasy with substantive canons, because substantive canons are about judges identifying policy issues that they think are important, usually constitutionally motivated, but not always. And that therefore they're going to put like a thumb on the scale and say, Congress, if you want to do something, you've got to speak clearly, or you've got to otherwise kind of override our value judgment that you can't do this. And so there was this discomfort, although I love the major questions doctrine as a policy matter, or at least some version of it, and we could maybe go through and see which version. As a matter of like law, it was unsettling. And I think like at least the biggest intellectual development in Biden versus Nebraska is that Justice Barrett came in and wanted to say, all right, old-fashioned textualists, I'm an old-fashioned textualist too. Let me give you the reason, the foundation for a linguistic, maybe linguistic's not the right word, and Brian will correct me, or at least a textualist, approach to the major questions doctrine. Brian, maybe you could just kind of walk us through a little bit of the concurrence and what they did there.
Okay, I'll just read the key paragraph from Justice Barrett's concurring opinion because I think it's interesting, and it's interesting, I think, to a broader group of people than would normally follow a case like this, especially if they don't have some stake in it, because she mentions babysitters. She talks about babysitters, which caught the imagination of my wife, who's not an attorney or interested at all in what I do, except in this one situation, because it involves an instruction from a parent to a babysitter, and which brings all the ordinary interpreters out of the woodwork, including my wife. So I'll just read the paragraph. So Justice Barrett, and then I'll talk about what Justice Barrett was trying to accomplish and maybe why the other textualists on the court didn't sign on to her opinion or really mention it at all. So she says, this is Justice Barrett, her concurring opinion, Biden v. Nebraska. She says, consider a parent who hires a babysitter to watch her young children over the weekend. As she walks out the door, the parent hands the babysitter her credit card, mistake number one, probably, and says, make sure the kids have fun. That's in quotes, make sure, so that's the instruction, right? So the whole idea is, what do we make of this instruction? Emboldened, the babysitter takes the kids on a road trip to an amusement park where they spend 2 days on roller coasters and 1 night in a hotel. Nothing about how far away the amusement park is or anything about that. I guess that's not part of the context that matters. So Justice Barrett says, and this is going back to a direct quote, was a babysitter's trip consistent with the parent's instruction? Maybe in a literal sense. So Justice Barrett's making a distinction between literal meaning and ordinary meaning. She says, because the instruction was open-ended, but was the trip consistent with a reasonable understanding of the parent's instruction? Question mark. Highly doubtful. In the normal course, permission to spend money on fun authorizes a babysitter to take children to the local ice cream parlor or movie theater, not on a multi-day excursion to an out-of-town amusement park. If a parent were willing to greenlight a trip that big, we would expect much more clarity than a general instruction to, there's quotes again, make sure the kids have fun. All right, so that was kind of the heart of the hypothetical, and Justice Barrett also had another hypothetical involving apples that no one's really talking about. Everyone's
not as
focused
fun. It's just
on-
not as fun.
But the apples hypo doesn't work for other reasons. It's indeterminate. But all right. But the babysitter hypothetical. So, in thinking about the major questions doctrine and textualism, I think there's kind of three different maybe approaches to legitimizing a canon, an interpretive canon. One is what Bowd and Sachs wrote about in the Harvard Law Review a few years ago, called the law of interpretation. And it's this idea that interpretive canons can be part of our law of interpretation. And so they don't need a linguistic legitimization or a normative justification, but instead they're just part of this law of interpretation. And maybe that's what Justice Roberts was thinking about when he wrote the majority opinion. He basically just pointed to precedent and said kind of the time to debate the major questions doctrine is past. We can just cite West Virginia, the EPA, and maybe other cases. It's settled law now, debate over. I'm not sure, not that I can speak for all textualists, I'm not sure that would satisfy any textualists, because at some point the doctrine was created, and I think textualists want some theory at the time the doctrine was created as to how that comports with the Constitution or language or some other justification. But that would be one theory, kind of the law of interpretation theory. A second theory would be a normative theory as a substantive canon. And Justice Barrett disclaimed that as a basis for legitimizing the major questions doctrine. And there's been a lot of discussion recently about substantive canons, otherwise known as normative canons. Ben Idelson and Matt Stevenson have just published an article in the Harvard Law Review titled The Incompatibility of Substantive Canons and Textualism, where they make an argument that textualists should reject substantive canons as being inconsistent with textualism. And Justice Barrett seems to kind of go along with that. So I would say that's kind of even a stronger position than Justice Scalia's version of textualism, where he seemed to have some problem, especially with stronger canons, but he had more the law of interpretation view, that these are kind of long-standing interpretive principles that maybe it would be more harmful to reject them at this point rather than just accept them. So another kind of, so within substantive canons, there's kind of two categories. One would be clear statement canons, and a lot of scholars are arguing that the major questions doctrine is a clear statement canon. The other category are tiebreaker canons. Tiebreaker canons resolve ambiguity, and you can appreciate that tiebreaker canons are much less controversial than substantive canons. In fact, Justice Barrett herself says she does not have necessarily a problem with tiebreaker canons. She doesn't have a problem with the idea that textualists can account for policy, can consider policy in resolving ambiguity. But, Elon Werman, who I think isn't here, but he recently wrote a paper that's being published in the University of Virginia Law Review. I can't remember the title right now.
I can't remember it either.
Well, you can Google it. But he wrote a paper where he is arguing that the major questions doctrine is a tiebreaker canon and is legitimized. Well, it's a tiebreaker canon that also comports, that is linguistic in a sense. This is Werman's argument, because it reflects how ordinary people resolve uncertainty in high-stakes situations. All right, so the tiebreaker canon theory is still a substantive canon, still a normative canon, but maybe a less dangerous kind of canon. But interestingly enough, Justice Barrett does not argue that the major questions doctrine is a tiebreaker canon. In fact, Gorsuch and Alito are arguing that it's a clear statement canon. But I will say in Elon Werman's defense, recall he's characterizing the major questions doctrine as a tiebreaker canon. And in his defense, in major questions doctrine cases, the court does reference ambiguity a lot. And I don't know if it's all of the cases, but in many of the cases, the court labels the relevant statutory provisions as ambiguous, which provides a basis for arguing that the major questions doctrine is a tiebreaker canon that resolves ambiguity. All right, so Justice Barrett, though, doesn't make that argument, but she also argues that the major questions doctrine is not a clear statement canon for a couple of reasons. One is that in her view, if something is a substantive canon, it cannot also be linguistic. So she sees these as mutually exclusive categories. You're either a linguistic canon or a normative canon. And her other argument that the major questions doctrine is not a linguistic canon, she says the major questions doctrine doesn't require the level of clarity that other clear statement canons require. So in Justice Barrett's view, the kind of necessary authorization can come from specific language, but it can also come from context. So when Justice Barrett discusses the babysitter hypo, she says, recall the language, make sure the kids have fun. Justice Barrett doesn't believe that language is precise enough to give the babysitter authorization for that trip to the amusement park. But Justice Barrett says, well, the authorization can come from context, which makes the major questions doctrine not a strong clear statement canon, like maybe some other canons, presumption against retroactivity, canons like that. So Justice Barrett says authorization can come from other contexts, like maybe the babysitter is a grandparent. Does that give them authorization? Maybe, I guess in Justice Barrett's world, I'd let you all decide if your grandparents or not, whether you have special authorization. Maybe other contexts that would bolster the babysitter's claim to have authority. So Justice Barrett claims that the major questions doctrine is not a substantive canon. Instead, it's a linguistic canon. So what is her basis for making that claim? Well, and in this sense, Justice Barrett is being consistent. She's drawing on an article that she wrote in the University of Chicago Law Review several years ago called Congressional Insiders and Outsiders. And in that argument, she drew a distinction in the basic approach to statutory interpretation. So there's congressional insiders, and congressional insiders look at Congress. So congressional insider might look at legislative history, the rules of how legislation is created, and make inferences based on legislative history and other evidence about what Congress was intending to accomplish. And Justice Barrett says that's not textualist. Her view of textualism is that textualists are outsiders. So instead of looking at Congress, congressional outsiders, textualists should look at ordinary people. Although she does, within that article, she does qualify that some. So she says, and this is a quote, sometimes a relevant reader may be a layperson, so ordinary people, and sometimes she may be a lawyer. So she also talks about ordinary lawyers. And she probably does that to kind of get around the problem of legal terminology, right? How are ordinary people going to understand legal terminology? Well, if you can kind of put that objection to the side if you say, well, maybe really the standard is an ordinary lawyer. But interestingly enough, in Barrett or in Biden v. Nebraska, Justice Barrett seems to focus exclusively on ordinary people. And even when she ties the major questions doctrine to Congress and how our expectations about how Congress legislates, she doesn't discuss how an ordinary lawyer thinks about Congress and how an ordinary, the expectations of an ordinary lawyer. Instead, she exclusively talks about ordinary people, and she doesn't explain why she's so focused, especially in a regulatory context, why she's focused on ordinary people instead of ordinary lawyers. And of course, she also has to explain what we should assume ordinary lawyers understand about the legislative process. So Justice Barrett's argument is that ordinary people have certain understandings about rules and about instructions. And the kind of primary themes, and Justice Barrett kind of repeats these themes many times in her concurring opinion. The kind of overriding themes are common sense and context. So in Justice Barrett's view, ordinary people interpret non-literally sometimes, and they're guided by common sense and context. And just as ordinary people are guided by common sense and context with respect to kind of everyday situations, they're also guided that way in their expectations about how Congress legislates. And I guess the larger issues are, which I know Tara's going to want to talk about, is this compatible with textualism? Are textualists comfortable with this idea that semantic meaning can be overridden, rejected by this kind of notion of common sense? I can't imagine Justice Scalia would sign on to that kind of reasoning, even though Justice Barrett and all the other textualists, or at least some of the textualists on the court, claim to just be signing on to Justice Scalia's version of textualism. And the other interesting kind of implication from this is it really opens the door, thankfully for me, I guess, because I'm interested in this kind of scholarship, to empirical. These are empirical questions.
I wanted to jump in and
Sorry, I didn't mean to.
No. So we got a lot of textualists in this room. The nanny example. Yeah. How many of you think that the nanny was permitted, or the babysitter is permitted, to take them to a 2-day amusement park trip? As a matter, you're a textualist, right? Are you okay? How many say no? Interesting. Dan, what was the result on yours when you did the?
It was
Amazon
not bad. Yeah, so we did a study together with Kevin Tobia of Georgetown, and definitely recommend that you download it and engage with it, but
and cite it, even if you're going to criticize it. Citing's good, right?
Sure.
It's gotten some pushback though, which the room reflects the pushback. A couple of people.
What were the results? What's the bottom line? You asked 4 different questions.
Well, first of all, I just want to highlight we had an actual representative sample of respondents, which is important distinction. Perhaps leads to the different results. However, so just I don't want to get too bogged down in the details of the study because we're pretty limited on time here, but we asked questions related to both the Wurman theory and the Barrett theory, as articulated by Brian. And we didn't find that either theory was really well supported among ordinary people, the people that we polled. I want to spend more time on the Barrett results because I think those are the ones that have gotten more traction and people think are probably more convincing. So we gave a variety of scenarios in our survey. We had a situation of what we called, well, we'll just start with the basic one, a reasonable situation. Blake uses the credit card to buy the children pizza and ice cream and to rent a movie to watch together. So that's one question that was asked to a subset of the respondents. And I think all of us would say that's reasonable, right? Raise your hand if you think that's reasonable, given the authorization. Absolutely. Fair point. So as survey experimenters do, we gave a variety of scenarios. So beyond the reasonable, we also gave a major example, which closely followed the one that Barrett talked about. So Blake uses the credit card to buy the children admission to an amusement park and a hotel. Blake takes the children to the park, where they spend 2 days on roller coasters and 1 night in a hotel. Okay. In addition, we added a few others. We added a misuse situation. Blake only uses the credit card to rent a movie that he watches alone. Blake doesn't use the card to buy anything for the children. We added a minor condition. Blake doesn't use the credit card at all. Blake plays card games with the kids instead. We then added an extreme situation, kind of on the other end of the spectrum. Blake uses the credit card to hire a professional animal entertainer who brings a live alligator to the house to entertain the children. Okay, so what did our results suggest? We asked respondents whether this was reasonable given the instruction to the babysitter. So start with the reasonable one. On a 7-point Likert scale, pretty close to 7. So your intuitions are correct, or at least representative, I should say. What about the major situation, the one that Justice Barrett said was clearly unreasonable? A little above 4 on a Likert scale. So on the reasonable side of the spectrum, although less reasonable, considerably less reasonable than the reasonable scenario. Now, the really interesting stuff is on the other example. So we found that the extreme condition, the live alligator example, was less reasonable than the major example, but still about in the middle of the Likert scale. So on average, most people were likely to say it was fairly reasonable. Okay. What about some other conditions here? Minor was considered to be very reasonable, up near reasonable, so about 6 on the Likert scale. And then misuse, this is the one that I find the most interesting, right? So under implementing the instruction to the babysitter, that was viewed as less reasonable than just about every other scenario. So people were highly troubled by the babysitter not really following through on the instruction at all. Okay, so that's kind of an overview of the results. Now, what do you take from all of this? As survey experiments are often want to be, it's in the eye of the beholder, right? But our take is that this complicates the story, at least to the extent that Justice Barrett really is leaning in on the ordinary person rather than the ordinary lawyer. I think it raises that question that needs to be resolved at some point by the textualists on the court, whether we are supposed to consider the ordinary reader's plain meaning or the ordinary lawyer's plain meaning. And I think that question is very fraught, and it's pretty understandable why the court has avoided it to date.
All right, Tara, do you want to jump in on textualism and major questions?
Oh, boy. So where to start? So I think it's important to recognize that textualism is a big tent. And this is something I've written about and some other people have written about too. And so in the Stevenson-Idelson article that says substantive canons are at odds with textualism, they're really talking about a very strict form of textualism, one that I endorse, but that many textualists do not endorse. And so I think the compatibility of the major questions doctrine really depends on your attitude towards textualism. I also think we should be careful when we talk about Justice Scalia's version of textualism, because Justice Scalia himself changed over time. So if you read A Matter of Interpretation from the late 1990s, Justice Scalia looks like a very strict textualist. If you look at his treatise, Reading Law, there are there's a huge section of that treatise devoted to substantive canons that apparently are okay in Justice Scalia's view. And even strict textualists like myself acknowledge that some substantive canons are so historically grounded, it may be hard to get rid of them. And so I think of textualism as kind of a spectrum. And so when we talk about the incompatibility of textualism with anything, I think it's important to keep in mind just how complicated textualism itself is. So that's just generally on what I'm calling substantive canons. On the major questions doctrine, I think it has to be a substantive canon. I think that Justice Gorsuch is quite honest in his West Virginia versus EPA concurrence, saying this is really the best I can do because I can't get the non-delegation doctrine enforced on the court. I find this highly problematic on textualist terms in terms of my version of textualism, but at least that is a candid acknowledgement. Hey, I'm a textualist up to here, but I do have this one doctrine I'm going to stick in. I think that the effort to justify the major questions doctrine as a linguistic canon, and thus just part of reading a text, is, to my mind, much more problematic for the long-term legitimacy of textualism as a matter of theory. At least if you're treating textualism as a strict version, which a lot of these theories are, and Justice Barrett attempts to do. Now, I will preface my remarks about her concurrence with, I love Amy Barrett. She was one of the kindest professors in all of federal courts to me my entire career. I think she is one of the nicest people I have ever known. So I just want to say I have great affection for former professor, former judge, and now Justice Barrett. But I find her concurrence not persuasive. So there are a couple of things she does in the concurrence that I think are kind of telling. She starts off by saying, in this case, the court applies the ordinary tools of statutory interpretation to conclude the HEROES Act does not authorize the Secretary's plan. The major questions doctrine reinforces that conclusion, but is not necessary to it. And this is something we haven't talked about on this panel. Actually, Chief Justice Roberts' opinion doesn't purport to rely on the major questions doctrine. It says that, look, if you look at this text, it doesn't authorize the student loan plan. And I'll say, I think it's actually a really difficult textual question, putting aside any sort of extra textual doctrines. I think if you look at the HEROES Act, it's a very tough call whether the majority opinion or the dissenting opinion is right about that. So I think one can certainly justify the majority opinion just without any reference to the major questions doctrine. But here's the thing. Then Justice Barrett goes on to say, the major question doctrine grows out of the same common sense principles of communication. If that were true, we wouldn't need something called the major questions doctrine. It would just be part of the initial textual analysis because, of course, all textual analysis involves context, and textualists disagree about which context you're going to stick in there, but it involves common sense notions of communication, common sense in the context of legislation. And so it's odd to say that we have this textual discussion and that there's something else, unless that something else is doing something that is a little bit more substantive. Justice Barrett goes on to say, the expectation of clarity from the major questions doctrine is rooted in the basic premise that Congress normally intends to make major policy decisions itself, not leave those decisions to agencies. As Justice Breyer once observed, Congress is more likely to have focused upon and answered major questions while leaving interstitial matters for agencies. ... That makes eminent sense in light of our constitutional structure. Because the Constitution vests Congress with all legislative powers, a reasonable interpreter would expect it to make the big-time policy calls itself rather than pawning them off to another branch. End quote. What does this sound like? It sounds like the non-delegation doctrine, right? Exactly what Justice Gorsuch said the major questions doctrine is supposed to do. Quickly realizing this, Justice Barrett goes on in the next paragraph to say, crucially, treating the Constitution's structure as part of the context in which a delegation occurs is not the same as using a clear statement rule to over-enforce Article 1's non-delegation principle. I don't see how, frankly, under this analysis, the assumption underlying Justice Barrett's and Professor Alon Werman's article is that we just get that Congress makes decisions and agencies don't. And who is the we? The we seems to be everybody that people who believe that principle talk to. But let me just tell you about a different person named John Manning, who wrote the following thing in 2000, an article called The Non-Delegation Doctrine as a Canon of Avoidance. John Manning was writing about the Supreme Court's decision in FDA versus Brown and Williamson, and said, look, I get that you Supreme Court don't want the FDA policing cigarettes. It is kind of weird. They haven't done it for decades and decades. But you know what? If you look at the statutory definitions, if you look at the statutory text, it seems to allow the FDA to do just that. And to get around that, Supreme Court, you're applying what sure looks like purposivism. He says in that article, quote, the court has recognized that if faithful agent theories of statutory interpretation are to be given effect, the statutory text may well transcend the precise purposes that inspired it, and that the judiciary must respect Congress's choice to legislate in open-ended terms. By artificially narrowing an open-ended statute to its background purpose, decisions like Brown and Williamson upset the terms of such a legislative compromise, period, end quote. So at least this observer does not assume that Congress does every big thing and agencies don't. And I'll say, growing up myself, I didn't either. Earlier today, my 12-year-old son, who, as I mentioned, is in DC right now, we walked past the EPA building, and he said, to my surprise, I like everything the EPA does. And my husband said, maybe not if you knew a little more about the EPA. But my son was basically saying, I like environmental protection, and that's what it does. And let me just tell you, I'm a big law person, but I don't go around at home talking about the EPA. He did this reading up on his own. And I'm just saying, my 12-year-old son, earlier today, was basically saying, I like agencies. My point being, there is no linguistic canon out there in this country that says Congress, yes, agencies, no. And we can only get there with normative conclusions that that's the way it should be.
So I want to jump in on this, I mean, what do you do with the Bressman and Gluck study? In other words, you know, when Lisa Bressman and Gabby Gluck sat down with 146 correctional staffers, interviewed them, one of their big takeaways was that Congress doesn't mean to give interpretive authority to agencies over big questions. And it was a recurring theme to the extent that in their second article, they did 2 big articles on this, they kind of wax poetic about this, that the relationship, that when Congress drafts statutes that govern agencies, their primary audience is the agency, not the courts, not the public. They're speaking to the agency, and that they want the agency to have the primary authority over things where they have expertise, kind of the Breyer approach. Like, Breyer got this right. Now, granted, that was a different major questions doctrine than we have today, although if you ask Lisa, I haven't asked Abby, but I have asked Lisa, she says that wouldn't have made a difference in their interviews, that they were really talking more about whether the agency had the authority to regulate big questions. And I wonder, like, how does that fit in? Maybe that doesn't fit in with your version of textualism at all, but if the idea is you're trying to understand the conversation as Lisa and Abby, or sorry, Professor Bressman and Professor Gluck, they're out here all, you know, what they were saying, the conversation between the agency and Congress, that's our goal. And that's what the court's role is doing, is to try to patrol that relationship. Shouldn't it matter that congressional drafters would agree with what Chief Justice Roberts said, that this is a matter of separation of powers and congressional intent when it comes to major questions?
So first I'll say, and I should preface this, I'm not a big fan of having executives do lots of stuff. I actually want more congressional power. Part of a Princeton initiative right now on congressional power. I'd like to see Congress do more things, generally speaking. But Congress does, in statutes, delegate to agencies. So a couple of things on the Bressman-Gluck study, which is incredible amount of work went into that. One of the primary goals is to critique textualism in that study, right? And so I think they would agree that a lot of what they came up with is not consistent with at least what they viewed as proper textualism. I think too, and I realize this could be considered a cheap shot, but I think it's actually a really important aspect of the article. They interviewed staffers, not legislators, and not even all staffers. And I think it's important to recognize that the staffers don't actually vote on laws. Yes, they're involved in the drafting, but there's a reason that they're not elected. You know, when I clerked for a judge, people say, oh, you had so much power. And I said, no. There was somebody who was nominated by the president and confirmed by the Senate, and I was there to serve, right? Like, a law clerk is not the person you should ask about an opinion. It's the judge. And they can't ask members of Congress. Even if they did, I think, as those of us who believe in textualism would be highly skeptical of the subjective intent of individual members of Congress. We're a few steps removed, and I think that's important.
Dan, do you want to jump in?
Yeah, just really quickly, I think it's pretty odd to rely heavily on kind of a meta intent of Congress if we're really skeptical of a specific intent of Congress. And you know, I share a lot of the other observations that Tara made as well about you know, the focus on staffers perhaps being unrepresentative. So well, it's evidence, right? It is part of the context. I think it raises a lot of questions that haven't been answered yet. So I don't find it particularly persuasive at this point. You know, maybe with more studies that show that legislators also share those views, and then also perhaps a recognition that sometimes intentionalism can be justified as part of the context of interpreting statutes. I think then we can have a conversation, but that's just not textualism, right? Like, as it's been defined, and we're all textualists now, as Justice Kagan said.
And this is probably obvious, but Justice Barrett would say that the results of that study are uninteresting to her because that's an insider approach, and she believes in interpretation from the outside. I just want to say one more thing about kind of in response to what Tara said about the major questions doctrine and Justice Barrett's argument that it's linguistic. I think Justice Barrett would concede that it's not linguistic in the same sense that Sam rule about a comma is linguistic. And so I think Justice Barrett would see kind of the determination of the meaning of a statute from the outside as kind of being composed of two parts. The first part, of course, is determining the literal meaning, and she would concede that the major questions doctrine is not relevant to that. But the second part, where Justice Barrett would say common sense and the major questions doctrine as just being representative of common sense, is the second part where you decide whether the literal meaning is going to control or instead, like the babysitter example. So Justice Barrett concedes that the instruction, the literal meaning of the instruction to the babysitter would authorize the trip to the amusement park. But where the major questions doctrine comes in is this kind of second step where you reject the literal meaning. And I'm not, this is kind of a defense of how Justice Barrett sees this kind of, where this linguistic kind of part comes in.
Can I just respond to that? I don't think, I think it's very kind of you to try to sort of support it, but I don't think Justice Barrett would have described the textual analysis in the majority opinion to which she signed on as a literalism, the HEROES Act. I don't think that that's what the Chief Justice was doing, and I don't think that's what Justice Barrett suggests that the Chief Justice was doing. And if she did, that would be anti the entire history of textualism, which is not, especially modern textualism, but I think goes back deeper. Modern textualism, everyone agrees, is not literalism. So she's still making that distinction in the analysis.
So I've got like 10 more questions on major questions doctrine, and we got a little more than a half hour, and I'm reading the room. There are people that want to ask questions. I want to do, before we get to Randy, and you're first in the queue. I do want to talk about the future of student loan cancellation real briefly, and then I have a feeling we're going to go right back to the major questions doctrine, which is fine. So just to kind of give you a sense of where things are at, the Department of Education, I think, is listening to the Supreme Court and kind of reading the court. And they are now engaged in a negotiated rulemaking with key constituencies and focused on like 4 narrow categories. Well, how narrow they are will depend on what comes of it, right? But just to kind of give you a little bit of a sense of this. One is where they're focusing on borrowers where the balance today is more than what they took out originally. So underwater balance, where the interest has overcome that. So that's one category that they're looking to provide additional loan relief on. The second is if they've been repaying for more than 20 or 25 years. So kind of those that are still paying after 20 years is the second category where they may do some more, or will do some more targeted loan cancellation. The third is for eligible borrowers who could have got relief under an income-driven plan or under the public service plan but never applied for it. Is there a way to kind of retroactively allow them to have that benefit and not fault them for not applying? And then the fourth is crappy schools relief. If you went to a school that failed to deliver, can we kind of relieve you of the debt for that? And we don't know exactly what, there is a proposed reg, although it's going through negotiated rulemaking. It'll eventually go through notice of comment. I have to say, I love all of this. I was highly critical of the Department of Education's first approach of kind of just randomly doing Q&As and shifting their policy left and right in litigation. I understand why. It was a grant program. I understand some of the reasons why it worked that way. But I am glad to see they're going through this. And I don't know, Julia, my kind of gut reaction, and I haven't dove into this really deeply, but reading through the regs and the different, the policy paper they've put out, these are all, could be very not major questions, like very narrow categories that may still fail under the statute. I don't know, but I don't think we'd run into a major questions doctrine. And you're looking at me like, yes, we would. I don't know.
I don't know. I'm the outlier here. I actually don't think we need a major questions doctrine, and that the court.
Oh, well, that's not fun.
Court did not need to go there. Frankly, I think it could have followed on the track that it had set out, especially in Brown and Williamson, and continued on. But turning to the future of student loan restructuring, it does bear emphasis that these incremental measures have added up to staggering amounts of money too. So you're right that the court was focused on the $430 billion estimated price tag and saying, whoa, this is a program of extraordinary political and economic significance. But these piecemeal student loan restructuring, student loan forgiveness and programs and so forth also add up pretty quickly to over $500 billion. So this gets back again to the idea that we have a de facto executive power of the purse in a way that is, at least arguably, in tension with the basic constitutional plan. Now, of course, the executive branch does spend a lot of money, does incur a lot of financial obligations for the nation, particularly in times of emergency. We, of course, the last 20 years or so have been living in a time of a recently coined and now popular word, permacrisis, where it seems the executive branch can always justify spending staggering amounts of money that one might think was, at least in the original constitutional design, supposed to be the province of Congress. So we'll see what emerges from this negotiated rulemaking, which is taking place under the HEA, the Higher Education Act, as opposed to the HEROES Act, which provides for a bit more process. In addition to the executive branch, though, I think we should also focus on other actors who can be active in the student loan restructuring arena. One is courts. Student loan debt is very hard to discharge in bankruptcy, but it is possible under current bankruptcy laws for, in cases of undue hardship, for there to be discharges. It would be, I think, possible for courts interpreting that phrase to allow for a bit more discharge. Most importantly, Congress can act and arguably should. The various discussion, the various potential initiatives are, I think, piecemeal and are only lightly targeted at what I see anyway as the most important question about the massive student loan debt held by the United States government. It is $1.6 trillion. And whenever I tell people that the student loan debt portfolio of $1.6 trillion is the largest financial asset of the U.S. government, people laugh because they know that it is not worth $1.6 trillion. Right? Why is it not worth $1.6 trillion? Because no one thinks that it is going to be repaid in full and on time. So many people are already in default. Those who got degrees that are in no way, shape, or form worth the money. Now, we have a system where there is bad debt, and there is, of course, in any capitalist system, bad debt, that has to be restructured and or forgiven in some way. Yet we have set up a system with student loan debt where that is very, very difficult. And so we get all these piecemeal various things where there are suspensions, people are then don't have to pay for a while, or if they don't pay, nothing really bad happens to them except that their debt keeps increasing. And looking around, we see just terrible ramifications of this. We see people who are over 50 who have student loan debt that is more than 100% of what they originally borrowed. We see parents who are on Social Security who co-sign some of these loans, including loans for degrees that, yes, were not worth the money. So it seems to me that very likely only a comprehensive reform spearheaded by Congress is likely to get at the problem satisfactorily. And any reform that does not address the soaring cost of higher education is simply setting us all up for another round of student loan debt forgiveness 10 years, 20 years down the line. The political economy considerations of this are, of course, formidable in that as the federal government has backstopped student loans, that has taken away one of the most important restrictions on the ability of higher ed to raise its tuition and fees. We have all seen the result. We see staggering amounts of money spent, and a lot of that money gets recycled back into the Democratic Party because the higher education is, as a sector, one of the biggest donors to the Democratic Party. So it's very, very difficult when one of the major political parties is getting so much money from a sector of the economy. It's hard to reform it. Yet I would argue anyway, reform it we must, because a lot of people are carrying way too much debt. It is interfering with their ability to buy homes, to start families, and so forth. So I would say, do not forget Congress.
Anyone else want to weigh in on that?
Yeah.
All right, let's open up the queue.
Suggestions.
I've got more questions, but we'll give Randy first. Yeah.
So I feel like I'm wading into some dark territory with you textualists. I'm just a poor, humble originalist. I really wish Larry Solomon were here. He's the one that should be saying what I'm about to say. So I'm going to be doing a Larry Solomon impersonation and invoke the philosophy of language to understand some of the results in your survey, I think. And that is, if you're looking for the communicative content of a text, whether it's the Constitution, I think, or a statute, there's really two components. A Gricean approach to philosophy and language says there's two components to that. One is semantic, and the other is pragmatics. So the semantics are what you would sometimes call the literal meaning, and it is basically based on word usage. And semantics can be open to a wide variety of meanings. We include a wide variety of meanings. But when we actually communicate with other people, people understand us not solely on the basis of the semantic meaning of what we say, but on the basis of the pragmatics or the context in which we say it. And so when I'm listening to your survey results, I'm thinking, when you get to some of the results that are very popular, both semantics and pragmatics are arguing in the same direction. And then as you move down your scale of examples, semantics is still there. But pragmatics or context is starting to drop, is starting to be disregarded, or at least context will argue, well, that's not in it, and this is not in it. But semantically, it's still in it. So some of your respondents are sticking, now that you're making them pick, you're forcing them to respond to a survey, and they're thinking about it, they're sort of sticking with the semantics. Oh, well, now that you asked me semantically, sure, I guess that's consistent. Oh, so it doesn't seem like common sense to me, but I guess it's consistent. So they keep answering yes. But as other people start taking pragmatics into account, they start answering it no, until you get to the part where it's in contradiction to the communication, which makes it neither semantics nor pragmatics, pragmatically enriched meaning, and therefore they get off the boat pretty much altogether. So it just seems that this is context, as Tara's already pointed out, is acceptable, it's admissible. So now the question is, what is the relevant context? And I don't think there's anything about Justice Barrett's opinion, which I haven't read, but I believe you're faithfully reporting to us, that seems contradictory to this. I think she's arguing that the communicative content includes both the linguistic or semantic meaning and the context, and in context, whatever follows from her position on the major questions doctrine, which I also don't have an opinion about. But this doesn't seem to be that mysterious. And so then the debate, and I don't think, and at some level of generality, purpose is part of the context. It just is. I mean, I don't care what anti-proposivists say, and I know that they're out there. Purpose is well-known purpose, widely accepted purpose, commonly shared understandings is just part of the communicative context in which we talk to each other and need to be factored in to figure out what the actual meaning of the text is. We're not adding purpose to trump the text. We haven't left the text behind. We're still within the text, but we're asking what meaning does the text communicate to other people? So I don't know if this is helpful or hurtful. I don't mean to be telling anybody on the panel how to do their job or the court.
But you just did. All right. Dan and Brian, we'll let you go first. I think Tara wants to jump in on this too, because there's at least a subtweet there.
Well, I think why Justice Barrett's concurring opinion is controversial is not just the language aspect of it, the common sense, the pragmatics, is that she assumes that ordinary people have a certain view of Congress and how Congress delegates and how Congress legislates. And whether that's just a matter of common sense, I think, is very debatable. So I don't think that's kind of just obvious that Justice Barrett's assertions about how ordinary people understand Congress, I think those are empirical questions that she could very well be wrong about. But I think just going back to this kind of distinction between semantics and pragmatics, I think Justice Barrett's doing something that is interesting and kind of aggressive. And so you have kind of pragmatics, which is just kind of, not to get into kind of too far into the linguistic weeds, but we can just think of it as context. But you can think of context as kind of very specific, just the inferences you draw from context and any kind of given occasion of someone making a communication. But you can also think of context in a more systematic way, where you're making a generalization about context. This is how people, so for example, with like a quantifier, a universal quantifier, or all, like when people use the word all, linguists have come up with a rule that all universal quantifiers are almost never meant literally. So that's a generalization about the way people use context that cuts across all communications. And I think Justice Barrett is making a claim about communication that's more general, that's more aggressive than just saying we consider context. She's saying, the way I read her concurring opinion is that people use common sense to narrow literal meaning, and they do this in a kind of systematic way, which I think is an empirical question. I think it's a much more aggressive position and understanding of how ordinary people interpret than just saying ordinary people use context, which we would all agree with. So that's my...
Dan, anything to add?
Yeah, I would just briefly add that, I completely agree that, context, pragmatics matter. I should preface this by saying I'm not a linguist like Brian, so this is not going to be as sophisticated of an answer. But, Barrett is invoking this example in order to say that the additional context of the kind of major situation leads us to view it as less reasonable, right? And we're giving just a variety of scenarios that vary on that same dimension. So, I don't think we disagree that context can be very important to the determination of statutes. The point, and I think our study underscores this, is, context is a very particular thing. The babysitter example itself doesn't quite make the case for the major questions doctrine, because we have additional questions about what is the additional context and who's the interpreter, what kind of context do they understand, right? So I think this gets back to something that Brian mentioned earlier, but like the, ordinary person versus ordinary lawyer distinction. Yeah, if you add enough context, somebody who went to law school, maybe they slightly change their view of how likely it is that Congress is to delegate power to an agency. But let's add a little bit more context. Let's say it's somebody who was in the American Constitution Society when they were a law student versus somebody who was in the Federalist Society as a law student. That additional context may very well matter, right, to what responses you get to whether it's major. I think this is all consistent with what we uncover in our survey, is that this is highly sensitive to context. But overall, there's a lot of willingness on the part of ordinary readers, at least, to follow the literal meaning of statutes to a pretty far degree, without allowing that additional context to really fundamentally transform their opinions of what's required.
I'll just say I have been skeptical in some of my writing of empirical surveys that try to test whether the Supreme Court or any given justice got an answer right. I do understand Justice Barrett kind of invited that here, and I understand why that sort of made sense. And I think Randy, the structure of your argument makes total sense, right? There's context, and it leads to an understanding of the statute. I think the difficulty here is that Justice Barrett is saying textualists don't like substantive canons. And this is what I've written in the past. To be fair, in her past writings, she did not reject substantive canons across the board. She said that to justify them, they need to be historically based, constitutionally based, and just sort of limited, which I think is sort of closer to the end of the textualism spectrum that I would like. But she's saying that that's not good. But the major questions doctrine is something different. And the way I read her analysis, that's not actually what it is. The major questions doctrine is a substantive normative assumption that Congress should make the big decisions and the executive should not. While it's a substantive belief with which I am quite sympathetic, that's not written into language, nor do I think it's easy to justify whether we're talking about a lawyerly meaning or ordinary meaning as a general understanding. If we polled lots and lots of people, if that were the way we did statutory interpretation, which I don't think it should be, I don't think that we'd get there. And so I think that's the flaw in her analysis, this assumption that we just kind of know when we see Congress has done something, that means the executive can't.
Oh, wow, we got a lot of questions. I think this was, and come up to the mics because this is being recorded and your voice can be recorded forever on YouTube. We've got time for at least 3 or 4.
So I had a couple questions, one for each issue. The first one was about the state solicitude. And so does the panel think that it matters what the source of state solicitude is for the purpose of these things? I mean, it would be a bit reduction to say just, well, a state is a state. I think there has to be something more than that to give one type of party to litigation different status, either for standing or for other things. So is it more the parents patriae idea that, oh, the state is important, it should always be at the Supreme Court, like Texas, I think, has been at the Supreme Court every single year for a while now, because they represent so many people? Or is it that they have special interests, for example, in standing, where their federalism interests in being parties as states to the federal union is being injured? So if there's a federalism issue, and so the direct injury falls on the state and indirectly its citizens, rather than a case where just, well, both these cases could be distinguished from just one person that's really bothered by litigation or by legislation and just tries to get it overturned, like Frothingham versus Mellon, which I think was about a woman that was bothered by welfare going to single moms because that encourages immorality. And that wasn't allowed. So my second question is about the separation of powers issues in the non-delegation discussion, the second part, which was the separation of powers is, I think, stricter in the federal government than perhaps almost every state government, maybe actually all of them. I haven't done that complete study. And so isn't there a realization that we have to do in debating the interpretive versus substantive or normative question, that essentially we're forced to live in sort of a triple inverted world where first the federal government is doing things way beyond the original structure, which are maybe difficult for it to do because it has very strict separation of powers, right? And then the second inversion, so that's a Commerce Clause issue. The second inversion is that we have to pretend that the executive is faithfully executing the laws by essentially creating laws because it was instructed, it was delegated to create these regulations, whether it's under a very specific narrow band or it's sort of a do-good statute like NHTSA. And so in dealing with both of those inversions, essentially Chevron comes and says, well, they can do certain things by implication, right? Or sort of they have this implied power to just make up gaps. And then Scalia says, right, elephants and mouse holes and all that. And so isn't it just easy to say that it's an interpretive rule because we're just narrowly construing an implied power that is already on the verge of what is constitutionally permissible because of the delegation issue, because the Supreme Court is trying to avoid bringing back non-delegation. So they just say, well, this is too big. No reasonable person could think that when they said, ensure that the air isn't polluted, that now we're going to say that carbon dioxide, which is plant food, is a pollutant, right? Going back to such an old statute, or sex in the case of all the gender stuff. And then
Okay, so let's that's a lot of questions. Let's do the standing question. If we have time, we'll go to the other one. But let's start with the standing
So
one.
I'd say very briefly, special solicitude can mean so many different things, and so my answer to you is, yeah, we can interpret it to have been suggesting anything that you just laid out, and so I would argue anyway that term special solicitude is really not doing any clear work. We do not need it. I would jettison it. So, Professor Grove.
So I'd split the baby a little more carefully, and Julia referenced this earlier. I've actually argued that states have historically and should get special access to the federal courts when they're trying to protect their own state laws from federal preemption. There's actually a fairly long history going back on that. What I see happening now is states claiming they have some special reason to go and challenge the executive's enforcement of federal law, which I think there's no reason that a state should have more power over the executive's enforcement of federal law than, frankly, any one of us. And that's where I think the problem lies. So I think states should be able to enforce federalism interests, but not the separation of powers, at least no more than anybody else.
It kind of Burkine seems to try to strike that balance,
Yes.
right?
Yes, I think very
At
much.
least that's how I.
I think you see the court heading in that direction. I think the real challenge is when the court allowed standing in Holland versus Burkine, it didn't tell us why. And so that leaves a bit of a gap in the analysis.
Ben, do you want to jump in on the other question?
Yeah, I mean, I think the problem with what you were suggesting with the major questions doctrine, that it's sort of just a non-delegation canon, interpretive canon of some sort, is that, the statutes in question in all of these major questions cases are clearly not problematic under the current non-delegation doctrine. I mean, it's not even a close case, really, under the intelligible principle standard. So unless we've implicitly changed all of that and sort of sub silentio thrown out, J.W. Hampton and all of its progeny, then I just don't see how that works, right? I mean, that's not how substantive canons work, where we just pick out a value that's not reflected in case law and in the law and run with it, right? Otherwise, there would be almost no limits on the court's ability to think up good normative principles that it wanted to, infuse in its statutory interpretation doctrine. I just don't think that's how things work.
So Dan's written a whole paper on this, and we don't have enough time. That's what substantive canons are. Like the federalism canons, like they reinforce values that aren't tied to actual constitutional cases, and there's so many constitutional avoidance cases where, like, it's not remotely tied to an actual constitutional holding. They create like a penumbra around, that goes far beyond. So I guess I just don't. I've never bought that.
So in my paper, I mean, maybe people don't buy this, but I think what's different about those canons is that they have a very narrow potential scope of applicability, right? So the federalism canons, and I talk about this in detail in the paper, but it's cabined how far these interpretive doctrines like the federalism canons will be implemented in the statutory corpus. The major questions is not like that, right? So it's not only weakly tethered to existing law, but it also applies to potentially any statutory interpretation, certainly involving agencies. So, I think that's it's sort of unprecedented. I argue in the paper that it's really only analogous to the absurdity doctrine, which is of course a very controversial doctrine. So anyway, I'll leave it at that.
I just had one.
Yeah, just real quickly, because we got like 7 people want to ask.
No, I'd just say there's a lot of, especially lower court cases where courts use the avoidance canon as a way to avoid the non-delegation doctrine case. And so I would be interested in the comparison between those cases and the major questions doctrine cases. I think they would be very different. But.
Yeah. All right, who's at the mic? Come up to the mic. Ben, do you want to go next?
Right here. Tara, one question was basically, could you understand the state standing? There is kind of an old view about how you could justify this. You could imagine this as like a nullification doctrine that's going to be judicially managed, aimed not at congressional statutes, but at like executive action, right? But it seems like a lot of the kind of old kind of Jefferson Calhoun arguments about like states are special and have special obligations, those arguments are like dead and buried in many other places, but that would provide some sort of argumentation, I think, for why states have a special thing. Dan, on your paper, I'm kind of curious, if you ask people whether or not, if you were the babysitter, would you have taken the card and gone 2 nights, gone for 1 night and 2 days, whatever else? How likely are you to have done that? My guess is you would not have gotten anywhere close to this, what you actually got. And so that makes me think a lot of is like kind of, the first month of law school, like, who's going to bear the risk when there's like the contract is unclear. So it seems to me like what potentially the respondents are saying is like, well, I can see why they thought that, and I don't think they should be held, responsible, because implicitly the follow-up is should they be in trouble for like being aggressive in some sense. But if they wouldn't have done it themselves, I think that's a better read of whether or not they think that's actually what the parent meant. And if that's true, then we should maybe think about this as who bears the risk of being wrong. And maybe one way to think about this is simply that the agency should bear the risk of going too far rather than the regulated bear the risk that the agency go too far.
You want to go first, or?
Yeah, sure. So one thing that Thomas Jefferson did not have either the state of Virginia or the state of Kentucky do was file suit, right? They wrote the Virginia Kentucky resolutions. And I think that's actually really important. So much of our constitutional discourse, as Keith Whittington and others have written, so much of our constitutional discourse in the 18th and 19th centuries was in the political process, right? I would love to have it there. And that is, of course, what the Supreme Court standing doctrine says. When no one has standing, this is United States versus Richardson, when no one has standing, that's a key indicator that this matter should be left to politics.
Just to briefly respond, I think that's interesting. Of course, the courts are in the position of the parents in real life, right? They're evaluating whether the agency, the babysitter, did the wrong thing. So, but I think it's an interesting thought experiment, and I'm totally on board with agencies, considering the majorness of their of the action when deciding whether to do something. I think agencies do that. Maybe not something that's widely shared as a view, but I think agencies are all the time clipping their wings. They only implement about 40 to 50% of their calls for regulation in statutes, right? So they're thinking about majorness for sure when they decide whether and how to take regulatory action. So I don't think that message is lost on them, and I don't think that it would be bad for them to kind of think as if the major questions doctrine was a thing, whether it is or not.
Well, they're definitely thinking about it now. Having interviewed hundreds of agency officials for different studies, I have to say, like, who's the they here too, right? I mean, the criminal civil service is like, I don't know, we can't do that. Like the statutes, that's a really aggressive read of the statute. Political comes in and says, we're going to do it. Okay, we'll figure out how to do it. I mean, like what is the they here? I don't know. I mean, it's such an interesting, they here would be the Secretary of Education. That's the person under the statute who's charged to do this. But it is fun to think about interpretation within the executive branch. Like who's the audience there? Do you want to, Brian, do you want to jump in real quick?
I was just say is,
I also, by the way, realize that's not your study. You were testing the ordinary person that Justice Barrett said we should be looking at, not the other audiences that we're kind of more interested in.
yeah, and within that context, some people have raised questions about, well, the ordinary person, is it the ordinary person in the position of the babysitter who has some involvement in the situation, or is the ordinary person and not a third party, an outsider, and maybe the results would change depending on whether you have some stake or whether you don't. And then that's a open question when we talk about the ordinary person. Is it a third party or is it someone who has involvement?
All right, we give Professor Sanders a last
We have time.
question.
Okay.
Yeah, let's do it.
So
We got 2 minutes.
I feel like this is such a non-academic, anti-intellectual question, I'm almost afraid to ask it, but maybe it's an appropriate endpoint to this. So I listened to all this, and then I see a couple of weeks ago, NPR had a story. It said, Congress passed so few laws last year, we summarized them all in 1,000 words. We all know Congress is broken. We all know Congress can't do the kinds of things that you and the court and other people are saying in theory is their job to do. To paraphrase Charles Black, I feel like, we have these debates because there's no ritually sanctioned way of explaining to the court Congress isn't going to do this, Congress can't do it. And so, should that factor into the calculation at all? I guess this is just more a statement of frustration than anything else, but I feel like this is all fascinating, but it's all extremely theoretical and divorced from the real world of how our political system and our separation of powers works.
Yeah, I've got a paper for you that no one here likes. I don't get invited to any FedSoc events anymore about how to make it easier for Congress to respond to major questions of doctrine. But I do think, when we're thinking about the doctrine as a normative matter, are we assuming a healthy functioning Congress or not? And when I mean that, not healthy functioning, they still do great oversight, but from a legislative perspective, do they have the power to, if there's a majority, to override a bad decision by an agency or a bad decision by a court? And I think those are really, really important questions. I don't know how they fit into what courts should do. Although sometimes when you read Justice Gorsuch, he envisions a version of Congress that I don't think we've had for a really long time, and I'm not sure what to do with that. I will say, to wrap up, on the flip side, some might say that the Constitution created a limited form of federal government that wasn't supposed to do a lot, and the Major Questions Doctrine is a way of course correcting a Commerce Clause jurisprudence that's out of control and the like. But that's probably a panel for a different day. We already crammed 5 panels into this one. But I want to thank the panelists here for participating today. Thanks so much.
Thank you.